right, excellent. Well, thank you. We have not had a webinar sponsored by our firm in many months, so we're excited to have a close out end of the year employment law recap for 2021. My name is Carl Habekost. I've been at Bugbee & Conkle about 11.5 years. My background is focused primarily in labor and employment, workplace safety. I have several certifications in that area, and I will be presenting some of the slides today. We are very pleased to have a new lawyer at the firm, Jade Robinson. Jade, do you want to introduce yourself?
Yeah, my name is Jade Robinson. I've been at Bugbee & Conkle for a few months now. Previously, I was working at a firm in Cincinnati, Ohio, during predominantly litigation, labor and employment litigation. Labor and employment law is what I'm passionate about, and I've been honored to be working at Bugbee and joining this practice group. And I'm published in Vaccine Mandates, which we'll talk more about later.
Very good. Thank you. And we are covering a variety of topics, so we'll move relatively quickly and hope that we have time for questions at the end of the presentation.
Yeah, so this is the outline of what we're going to be discussing today. So Carl will be discussing OSHA, cannabis and testing, workers' compensation. We'll both be talking about COVID-19. We'll fit in employment policies regarding all of those topics. I will touch on the FLSA for wage and hour. We'll talk about diversity training and also disability discrimination in the ADA. So,
great.
Carl?
Yes, thank you. I would like to briefly thank Brenda Humberson at the University of Toledo, Dave Varwig, a friend of mine who's a certified safety professional, and Don Ellswick as well from the University of Alabama, who gave us some ideas and subject matter for the presentation. Actually, we sort of summarized it all over a period of months. So you might ask, what in the world does Carl have an emergency action plan slide up there for? Well, you know, at least 70 people were killed recently in Kentucky, and I thought it might be the occasion not only to have a moment of repose and pray for the families and the people in Kentucky, but also to remember that you are required by OSHA to have an emergency action plan. Essentially, you need to have a written plan. You need to have procedures to deal with emergencies that are applicable to your organization. You need to train on the plans and have it in writing. So training both oral and written. Tornadoes. When I worked at the state of Ohio at the big building in the government center, we had tornado drills once a month. So everybody knew where they were going. There were team members that were responsible for approximately 10 people. So they knew who their team was and everyone was accounted for. Similar type of procedure for fires. You need to know the exit routes and various things like that. Phone numbers to call. So I just wanted to bring that up, and you have the Code of Federal Regulations regulation for OSHA that requires an emergency action plan. Well, we are now in a very strange environment, unlike anything that I've seen in my career. It's hard to get employees, and when you get good employees, you want to keep them. That's our main theme, by the way, for the webinar today. Employees are worth keeping. We are getting phone calls on a regular basis from clients about marijuana. The technical name is cannabis. And the real question is testing in the constant changes in the laws. So to set the context, cannabis is a Schedule I drug under the Federal Controlled Substances Act. What does that mean? That means it has absolutely no accepted medical use. according to the federal government. It also has a high potential for abuse and dependence, according to the federal government. But we have a government that operates by way of federalism. That means the federal government has jurisdiction, limited jurisdiction under the United States Constitution, and everything else is handled locally by the states. Well, this is an organic movement. States are legalizing cannabis regularly. I forgot the exact number, but I believe that something along the lines of 36 states that have legalized marijuana in some fashion, either recreationally, medically, or both. So we're now in a real mess. What does that mean for you as an employer? That means that you're going to have to deal with the patchwork of state and now even local laws. Municipalities such as New York City, San Francisco, just to name a couple, have their own cannabis laws. Every state that has some sort of legalization of marijuana or cannabis has a nuanced way of dealing with it. So not only do you have the legal issue, now you have the drug testing issue. How do you deal with that? Do you want a pre-employment test, or do you want to take that off of the panel of drug testing? And the other question we're going to cover is reimbursement under workers' compensation. That is a movement that is gaining some traction. We mentioned that the laws are constantly changing. There's the federal law and the state law. We know that because under federal law, Schedule 1, cannabis, otherwise known as marijuana, is illegal. That means any dependence or using marijuana, any restrictions based on marijuana use is not covered under the Americans with Disabilities Act from a federal perspective. However, it might be a protected activity and require some reasonable accommodation under the Americans with Disabilities Act under state laws. So that's one consideration you have to take a look at. Every state that we've seen has some kind of testing issue. And are you allowed to test? If so, under what circumstances? Is this case law driven? Are there administrative regulations? Every state is different. To make it even more complicated, July 14th, 2021, Senator Schumer and I can't remember the other gentleman introduced into the Senate a law called the Cannabis Administration and Opportunity Act that would legalize cannabis. That might solve all our problems. Okay, why would you test? Are you testing for impairment, or are you testing for mere presence? If you're testing for presence, I'll get into that, but that's a different kind of test than you would for impairment. Now, there's a new technology that has come about recently. It's testing for THC with a breathalyzer. Oral with saliva, that tests for presence in your system within the past 24 hours, blood within the past 2 weeks, urine within the past 3 to 4 weeks. It's been our experience that urine is the most common form of testing for THC in the system, and that merely shows presence within the use within the last 3 or 4 weeks. So what is the value of that? We're having clients who are having so much difficulty getting employees that they are taking marijuana or cannabis off the panel of drugs to be tested. Now, they still might have it post-employment for impairment issues. Okay, now in 2021, we are seeing changes in the law, and I touched on this earlier, but the real problem with testing for THC is the technology and then the database for the scientific analysis as to what level of nanograms in the system means impairment. For alcohol, where we have enough experience, we have enough data, and we have good enough testing to establish that a certain level of alcohol in your system means that you're impaired. We don't have that with THC yet. There's also the problem of active metabolites versus inactive metabolites. Active metabolites will result in impairment, loss of focus, slow reactions, and all you have to do is take a look at some of the very old Cheech and Chong movies and you'll understand what I'm talking about. So you always, however, need to consider testing for safety-sensitive positions. The safety-sensitive positions, however, are, I mean, we're running into the same problem when it comes to different states and different jurisdictions. And I'll give you an example. The United States Supreme Court determined that that their definition of safety-sensitive positions is endangering people's lives. If you're in New Mexico, a safety-sensitive position is defined as a position in which performance by a person under the influence of drugs would constitute an immediate or direct threat of injury or death to a person. Oklahoma defines a safety-sensitive job as a job or task that the employer reasonably believes could affect the safety and health of employees performing a task. And they specifically list dispensing pharmaceuticals, carrying a firearm, or handling hazardous materials. In Pennsylvania, safety-sensitive jobs are focused and limited to employment activities in small, confined spaces or jobs working at great heights. It's all over the place. We tell clients, just work and focus on taking care of your people. If somebody wants to hassle you from a legal perspective for being concerned about the safety of your employees, then bring it on. That's how I feel about it. We want to keep our employees, right? So keep them safe. And if that means you're testing for cannabis in a safety-sensitive position, then you're doing the right thing. All right, now, reimbursement under workers' comp. I only bring this up because it is a trend. In Ohio, we don't have to worry about it. We have a very clear and restrictive statute allowing medical marijuana in a very limited format. So we're not going to reimburse workers' compensation for workers' comp costs for medical marijuana. But New York and New Jersey allow it, but they don't require it. This is just a topic that I thought is raising its ugly head, and you ought to be aware of it. Nothing to be concerned about, but if you're trying to go to sleep at night, you want something that might put you to sleep, you can always think about reimbursement of marijuana under workers' compensation laws. Speaking of workers' compensation, COVID-19 and workers' compensation, I attended a webinar yesterday sponsored by the Toledo Bar Association Legal Medical Committee. And several members of the workers' compensation section gave a great presentation providing examples of COVID-19 claims. This is a very difficult subject matter for lawyers because it's difficult to determine the causal relationship between COVID-19 and work activity. While we throw around the term COVID-19, which is a coronavirus in substance, it's coronavirus, but it's a very strange strain of coronavirus that was found in late 2019. It primarily affects the pulmonary system. The coronavirus latches spiky surfaces. If you look at it under a really strong magnification of a microscope, you will see little spiky surfaces, and they latch onto healthy cells in your lungs primarily. That kills many healthy cells. There's also other symptoms, COVID toes, loss of smell, loss of taste, but the primary symptom is respiratory in nature. One of the best ways to combat COVID-19 is by way of vaccines. Now, it is a multifaceted approach. Washing hands, believe it or not, is one of the most effective ways to avoid unnecessary transmission of the COVID-19 virus. That is why the CDC, as well as OSHA, has recommended posting signs around, especially in the bathrooms, showing people how to wash their hands. That may be a symptom of the failure of our family to teach children how to properly wash their hands, but I'll leave that aside for a different topic someday. We have different vaccines. Primarily, we have 3 vaccines. We have the Pfizer vaccine and the Moderna vaccine. They are 2 similar vaccines. There is the J&J vaccine. It's a single dose. So the Moderna and Pfizer vaccines approach the COVID-19 issue by using something that's called a messenger RNA. It increases the longevity of the ability to defend against the COVID-19 virus. Boosters are now being recommended for all 3 vaccines. The J&J vaccine operates a little bit different. It actually introduces a harmless virus that then triggers an immune response. It doesn't matter, all 3 of them are effective. Now, the problem, as I indicated in workers' compensation, is a legal perspective, and I'm going to move through these slides relatively quickly. Burden of proof in any workers' compensation claim should be on the claimant. The claimant is required to establish by a preponderance of the evidence. That's more probable than not. It's not clear and convincing. It's not beyond a reasonable doubt. It's just more probable than not. But nevertheless, the claimant has to establish that they were injured or developed an occupational disease as a result of exposure at work or work activity. Claimant has the burden to meet that on each element of a claim. So it's my position that I will talk about here in the next couple of slides that COVID-19 is more akin to an occupational disease than an injury. If you go to the statute, which I've identified in this slide, there's a 3-part test for an occupational disease. That is a non-scheduled occupational disease. There are statutorily scheduled occupational diseases, but for non-scheduled occupational diseases, which would involve COVID-19, here's the 3-part test. The disease must be contracted in the course of employment. The disease has to be peculiar to the employment, and it has to create a risk. The employment itself has to create a risk of contracting the disease greater than the public in general. So we think of healthcare workers. That is the kind of work activity that one would think exposes the employee in a greater degree than the public in general to COVID-19. This is a legal terminology. Occupational disease claims generally result from repeated work-related exposures. And that's a conjunctive. And there is a causal relationship between that exposure and the diagnosis of COVID-19. The CDC has defined exposure to mean 15 minutes in close contact with someone who has COVID-19 or is a carrier of COVID-19. So casual contact is not going to generally be a basis for contracting COVID-19. Furthermore, at least that's the medical or the scientific data says that you have to have at least 15 minutes over, I don't know what it is anymore, 24-hour period within 6 feet. That's the kind of general rule. So if you're close contact with someone and they're a carrier of COVID-19 and you get COVID-19, more likely than not, the causal relationship would be established. This is the real problem with COVID-19 and workers' compensation. It's a communicable disease like the flu. Now, we have had cases where submitted to the claim file and it goes to a hearing is nothing more than a positive COVID-19 test result. And the claimant testifies that they got it at work. But there's no doctor relating the work activity with the positive test results. Is that sufficient to have an allowed claim? I don't think so. I only bring this up because I'm going to rule it out. Injury includes any injury, whether caused by external accidental means or accidental in character and result. In other words, slip and fall and you hurt your back. That's an injury. Is a claim for COVID-19 compensable as an injury or an occupational disease? I think if it's compensable at all, it's as an occupational disease claim. This is where I enjoyed the BWC presentation yesterday. The presenters discussed now what we are seeing for long permanent cases of COVID-19 and the symptoms and the damage to the body as a result. Permanent lung damage, neuropathy in lower extremities. One of the cases that was discussed, I believe, resulted in an amputation of one of the lower extremities. Myocarditis, that's inflammation surrounding the heart. And of course, psychological conditions. Mainly what we're seeing is depression and anxiety. So thinking that COVID-19 is not a big deal and you feel sorry for the people and you allow the claim, beware, this could be problems as far as risk management for your program down the road with permanent lung problems and these other conditions that I've listed on this slide. I just wanted to touch base that if you mandate a vaccine, if that's your policy, that the company has mandatory vaccine, and there is a bad reaction to that vaccine, that is probably a workers' compensation issue, and Jade may touch base on that in a second. But there is a difference between a mandate by the company and a voluntary choice by the employee, and we will get into the OSHA vaccine mandate emergency temporary standard here in a couple of slides. Jade, I think you might touch base on the next slide.
Yeah, so there are two bills pending in the Ohio House right now, one being House Bill 401. Under House Bill 401, Carl showed you the definition of injury under the workers' compensation statutes, but it changes the definition of injury and it explicitly excludes COVID-19 when the employer mandates the vaccine and any injuries that may result out of that. So that is explicitly excluded. We do not think this is likely to pass because it has been pending since it was introduced on August 24th, 2021 of this year. So there hasn't been a lot of action on it. However, House Bill 435 may be more likely to pass, which says the opposite of House Bill 401 and includes injuries due to the employer mandated vaccine as a compensable injury. But it specifically states that claimants cannot receive both workers' compensation benefits and CICP. CICP is federal funding. It stands for Countermeasures Injury Compensation Program, where individuals could receive funding for vaccine injuries from the federal government. And this statute, as currently drafted, pending bill, states that it would sunset. So any injuries that occurred past 2023 would not be compensable. And it has had more action. So as of September 29th of this year, House Bill 435 has undergone the first review by the Health Committee and has been referred to the Rules and Reference Committee. So it is about to be introduced for voting with the Ohio House. So that's the state of the pending legislation. I'm going to give it back to Carl to talk about his favorite topic, OSHA.
OSHA. Just wanted to let you know that we do sometimes get tunnel vision when we work in our area of expertise, but there is a federal program, a federal law that talks about workplace safety. It's the Occupational Safety and Health Act. The Occupational Safety Health Act is administered by the Occupational Safety and Health Administration. They both are OSHA. So what does OSHA say about COVID-19 in the workplace? Well, OSHA has had quite a bit to say in 2021. We will talk about the General Duty Clause, which simply requires employers to provide a workplace free of a recognized hazard or harm. In 2021, OSHA implemented or introduced a temporary healthcare emergency standard, and now the one that's getting all of the press and action from the courts is a temporary emergency standard for what is known as large employers, and that means employers with 100 employees or more. And there is something in there requiring a vaccine or periodic testing. Just because it's hard for me to get the teacher out of me, I wanted to let you know what the General Duty Clause is and what it says. You have to have a workplace that is safe. And if you know there are recognized hazards, then you have to take steps to mitigate those hazards or remove the hazards. OSHA uses this only when there is no specific regulation. I used an example of workplace violence. That is governed by the General Duty Clause. You might remember killer whales used to be a big activity, a big exhibit at SeaWorld. It is no longer because OSHA said that that was unsafe under the General Duty Clause, and SeaWorld could not find a way to make that activity safe, so they just stopped it. The question is, COVID-19 a recognized hazard in the workplace? I think the answer to that question is yes. The bigger question is whether or not vaccines are a feasible and useful method to correct a recognized hazard. So you see the elements of a General Duty Clause. OSHA has to establish that You, the employer, failed to keep your workplace free of a hazard. So we'll say that's COVID-19. The hazard was likely causing or likely to cause death or serious physical harm. Obviously, COVID-19 is very serious. The hazard was recognized by the employer. I think it's very difficult for employers to say this is not a recognized hazard. And there was a feasible and useful method to correct the hazard. That's the question. Are vaccines a feasible and useful method to correct the hazard? And I will tell you, OSHA is focused on COVID-19 and employers who are not following their recommendations. And that also includes the Center for Disease Control, the CDC recommendations to control COVID-19. This is what I was referencing. OSHA issued guidance on mitigating and preventing the spread of COVID-19 in the workplace. There are all sorts of activities and ways that an employer can reduce the spread or the risk of COVID-19 in the workplace. Multiple layers. That includes mask wearing, social distancing, increased ventilation. What we're finding out now is that increased ventilation is the best way to reduce the hazard. So I don't know if you remember, and you probably still see it, the plexiglass that used to be up all over the place. What we're finding out, at least what a lot of the scientists are saying, is that actually is harmful because it is reducing the air movement, the ventilation of moving of the air. So, you know, we don't really even know. And it's been very difficult in 2021 dealing with this because it is a moving target. It changes every day. So plexiglass was what we were supposed to be using. Now we're not supposed to be using plexiglass. Let's just have good ventilation. It would be nice if we could open windows anymore, but you can't open windows much anymore. So you have all of those controls. Vaccines are recommended. And of course, if you have an infected employee, you got to get them out of the workplace. Those are all recommended by OSHA's guidance. That is not the law, but they will use that guidance to say, you know what the correct things to do. You know the correct measures to control COVID-19. We got it right here on the internet, and you're not doing it. So they will use that as one method to issue a citation. The Healthcare Emergency Temporary Standard was promulgated on June 17th, 2021. That one, nobody had any problem with. It made sense. It expires now just in a couple of weeks. There is no permanent standard for healthcare relative to COVID-19. So we're not quite sure what's going to happen with the healthcare industry. However, every client that we have in the healthcare industry has some sort of mandatory vaccine program. So I don't know how much the expiration of the emergency temporary standard for healthcare is going to matter. This is the one where all of the court activity is happening. I mean, you can see they didn't waste any time. Issued on November 5th, 2021. Issued under this section of the United States Code that gives OSHA the authority to issue an emergency standard. Normally, it takes years to get a standard approved. But if there's a grave danger to employees, then OSHA can act quickly. The temporary emergency standard for large employers, that means 100 or more employees, was issued on the 5th. The very next day, on November 6th, the 5th Circuit, which is down around Louisiana, Texas area, they blocked it. What I mean by that is they held it in abeyance. The court wanted time to review the constitutionality of this temporary standard. They used language that said the emergency temporary standard gave cause to believe there are grave statutory and constitutional issues with the vaccine mandate. Just to let you know that this standard requires employers to make it mandatory for their employees to be vaccinated, or in the alternative, they have regular periodic testing for COVID-19. It used to be twice a week. I think that recommendation is now once a week, and the burden is on the employer to keep track of all of these records. And speaking of records, we get this question quite a bit. Is COVID-19 recordable? That means on your 300 logs, do you have to record cases of COVID-19? It's a sloppy answer, and I never liked it when I heard attorneys say this, but it's true in this case. It depends. You have to do your investigation. Here's the three-part analysis. The case is a confirmed medical diagnosis of COVID-19. It's work-related, and I'll talk about work-related in 1 second. And then more some of the general recording criteria. And for those of you who are obsessive compulsive, I gave you the citation and you can look at it. It's not relevant for my part of this presentation. Work-related, that means you got to do your investigation. You have to ask the employee how he or she believes they got COVID-19. What kind of out-of-work activities were involved? Did they go to, this summer there were state fairs. So a lot of our companies that are located in counties that are out in farm areas, they have state fairs. Well, within a week or two after the state fair, there were a huge increase of COVID-19 cases. That would be one factor, in my view, that would say, you know, it's more probable that your COVID-19 case is due to your social activity and not work activity, especially because we have a program, we social distance, we do different times that you come into work, different times you take breaks so you're not exposed to a lot of people. We have a mask policy. So, but you have to keep track of all that stuff. So I would say in most instances, COVID-19 is not OSHA recordable. I think this is
me.
yours? Yep.
Yeah. So we get a lot of questions about what to do when someone today in December 2021 tests positive in the workplace. So Carl was talking about earlier close contact, which is 15 minutes or more within 6 feet of someone. So if someone tells you that they tested positive, then you should look at who would likely have close contact with that person who tested positive. And tell them that someone who they've had close contact with or likely has tested positive for COVID-19. I wouldn't tell them their name or who it is because you want to keep an employee's medical information confidential. They may deduce who it is if you have a very small workplace, but you probably shouldn't say who it is that's tested positive. And then not only should you tell them, there are some things that you should consider recommending as well according to the CDC guidelines. So if you're tracking who is vaccinated and who's unvaccinated, then there's different recommendations. If you as an employer don't know who's vaccinated or unvaccinated, then I would just give everyone the unvaccinated recommendation. If they're unvaccinated, then the employee should quarantine for 14 days if they have symptoms, 10 days if they don't have any symptoms, and then 7 days if they can produce a negative test result. And if they're vaccinated, then we would recommend for them to get tested, but getting tested should be 5 to 7 days after they've had close contact with them. So a lot of people think it's immediately. It's not necessarily immediately. And then they should wear a mask for 14 days in the office, or they can stop mask wearing after they receive a negative test result. And there's no need for vaccinated individuals to quarantine unless the vaccinated individual also receives a positive test result. And then also a common question with vaccine mandates is whether HIPAA applies, and you can ask someone if they are vaccinated or not. And asking someone if they are vaccinated is not a HIPAA violation. HIPAA only applies to certain entities, like think of like your doctor's office or a hospital or other health-related entities, or who is bound by HIPAA. HIPAA is not an all-encompassing federal law. And the EEOC has confirmed that yes, you can ask whether someone is vaccinated, but it's limited to a yes or no response. So you don't want to follow up with, well, why haven't you gotten vaccinated, or anything like that, because those reasonings would trigger additional laws such as GINA, the Genetic Information Non-Discrimination Act, or other laws like that. So you just want to be careful about asking follow-up questions. Then another question we get is whether, regardless of all of the laws that are currently up in the air being blocked, Carl mentioned the emergency temporary standard. There's also a law applying to federal contractors that they get vaccinated that has recently been blocked nationwide, and the CMS healthcare law that's currently also being fought by the court. So there's a lot of laws out there, but that's not what is true today, since they're all pending and being fought in litigation. What's true today is that yes, private employers can choose to mandate the vaccine. However, there's exceptions to that. So this law is true under Title VII of the Civil Rights Act, the Americans with Disabilities Act, and the Ohio Civil Rights Act. So under Title VII and the Ohio Civil Rights Act, employees can have an exception to an employer mandate for religious reasons. So those religious reasons cannot be, just found that day. They have to be sincerely held religious beliefs, taking the place of a typical religion in one's life. Not political beliefs, not personal preferences, and you're allowed to question someone's religious belief if you think that it's not legitimate. And so there's some factors that you can weigh, like whether the employee has shown that they followed that religion in the past, whether the accommodation sought is likely to be sought for non-religious reasons, whether the timing of the accommodation request is suspect, and whether you, as the employer, have suspicion to believe it's not really sought for religious reasons. So particularly with the religious accommodations, you can question it, and maybe should question it during today's world, and you can ask for proof of that religious belief. One of the ways you can ask for proof is asking from a note from their priest or their pastor or whatever religion they are claiming a religious leader. You can also ask for materials showing that that religion believes whatever they're claiming is true. Additionally, for disability accommodations, you can ask for proof. If that proof is a lot more common sense, like a doctor's note or a prescription or medical records, things along those lines. And disability is under the ADA and the Ohio Civil Rights Act, and it's defined by the ADA as a physical or mental impairment that substantially limits a major life activity. Work is one of those major life activities. And just because someone asks for an accommodation doesn't mean you as the employer have to give them one. The religious accommodations under Title VII is under a undue hardship standard, which further is a de minimis cost, which is a lot of legal jargon. Basically, the employer has to analyze whether granting this employee the accommodation that they're asking, would it cost the employer more than a de minimis cost, which depends on the size of your business, etc. And you don't have to give them exactly the accommodation that they're asking for. If they want to work remote and you'd rather them work separately in a separate office where they can close the door whereas everyone else works in a cubicle, that could be an option. And they could continue to mask wear in the office while everyone else doesn't have to wear a mask. Those are all options for those employees under either Title VII or the ADA. And under the ADA for disability accommodations, you have to engage in what's called the interactive process. And our best advice for participating in the interactive process is document, document, document. So don't talk to your employee about their accommodation requests verbally. You want to make sure that everything is in writing and that you are balancing everyone's requests and not leaning more towards the employer, what they want, and really working together and figuring out if any accommodation would be possible for them. And of course, you don't have to implement a vaccine mandate, and a lot of employers may not be because of their workplace culture. That's one of the practical considerations. Workplace culture, if you are trying to retain your employees, especially during what's being called the Great Resignation, then you may not want to implement a mandate because you might have all your employees choose to work elsewhere that doesn't have a mandate. So that's just something to consider when choosing whether to implement a mandate. Additionally, from a practical perspective, you want to designate a committee or an employee who is going to be the one or ones who implement that policy. They should maybe draft the policy and hopefully work with counsel to do so. And they should track the accommodation requests. They should track people who are vaccinated when they get their first dose, second dose, whether they've sent an accommodation form, what their status is, and they should be tracking the percentage of vaccines, etc. So you should designate someone to do that so it doesn't fall through the cracks. Additionally, if your employer workplace is unionized, you should be thinking about if this triggers the right to bargain. It likely does until a vaccine mandate becomes state or federal law. It definitely triggers the right to bargain. So be aware of the collective bargaining agreement notice provisions that could trigger, that you could be triggering if you choose to implement a vaccine mandate. And it's silly to implement a vaccine mandate if you're not going to enforce it. So when enforcing a vaccine mandate, you want to follow the termination policy. So you should have multiple steps before you just end up in termination and have multiple deadlines. So for example, you should be vaccinated by January 5th, and you should have your second dose of the vaccine be done by January 30th. Have clear deadlines that they have to follow, so you're making sure that you're just not automatically terminating someone relatively quickly if they don't automatically turn in their vaccine paperwork. And have this drafted by counsel, as I mentioned, so that you're in compliance with both Title VII, the ADA, and the Ohio Civil Rights Act. And have the policy signed by an employee. Having the policy signed by the employee is great to use if the employee tries to say, I never got notice of this, I have no recollection of this, etc., and just gives you that additional leverage. Additionally, if the employee tries to fight the vaccine mandate, either by protesting, which we'll get into, or by seeking an accommodation, you cannot retaliate against them. They are protected by law, and this would possibly open you up to a lawsuit. So you can't terminate them for requesting accommodation, you can't demote or suspend them, you can't give negative or lowered evaluations, and you can't threaten them in any way. So just be aware of that and have your supervisors trained about vaccine mandates and what they can do if they know of someone's vaccination status or their request regarding a vaccine mandate. And then protests. In March, the National Labor Relations Board issued Memorandum GC 2103, which basically stated that they are going to become more aggressive in enforcing employees' Section 7 rights, which includes racial discrimination, health and safety rules, and it states that Section 7 rights include an employee's political and social justice advocacy connected to their interests as employees. So it could cover and does cover employee protests and walkouts related to vaccine mandates. And interestingly, it's not just an employer mandate that they're doing on their own, but also any government vaccine mandates. They could also protest those and still have their job be protected, even though the employer does not have any say in the government policies. Or maybe you do, depending on what kind of employer you are. And what does this mean for employers of what the NLRB is up to? Well, it means that since they're going to become more aggressive, and we know that, to educate supervisors and managers about the NLRB and Section 7 rights and what they should and should not be doing. For example, you shouldn't be prohibiting conversations about the vaccine mandate or any other policies that you implement. The employees are allowed to talk about it. They're allowed to talk about it on your time, whether we like that or not, and double check your solicitation and distribution policies. So if you have a policy about what an employee can give out at the workplace, be closely looking at that and maybe have your counsel look at that to make sure that you're not interfering with the NLRA, the National Labor Relations Act, which the NLRB enforces. And then people always ask us if they should implement vaccine mandates. And we don't think that you necessarily should, but you should strongly encourage the vaccine. One of the ways that you strongly can encourage the vaccine is to provide paid time off for employees to get vaccinated. And that will allow the employee to not have to miss work, miss pay, which is something that especially hourly workers really are considering about getting the vaccine. And you also just generally want to make sure that you are training your workers on COVID-19 policies and procedures. You want to make sure that you have an up-to-date COVID-19 policy and procedure. So if we drafted one for you in March of 2020, it may look a lot different now because we know a lot more about COVID-19 than we did back then. And you want to quarantine anyone who has close contact who's unvaccinated. Vaccinated workers don't have to quarantine unless they get that positive test result. And you can suggest that your unvaccinated customers or guests wear a face covering, but you don't necessarily have to. You can implement social distancing for unvaccinated workers. Maybe that could be a form of an accommodation. And you want to check on your ventilation systems and make sure that those are conducive to, clean air and not spreading COVID-19 that way. You want to follow all OSHA standards that the Carl was talking about before. And you finally want to make sure you're protecting your employees against retaliation. So set up an anonymous complaint box, etc. Make sure you're recording and reporting COVID-19 cases. So then we said we're briefly going to talk about the FLSA, the Fair Labor Standards Act, and how that applies to wage and hour laws, overtime, etc. Since employees are worth keeping, a lot of employers are considering implementing an incentive or a temporary bonus, so increasing their hourly wage just for a few months to make sure they have employees through the holidays, etc. And this would be a non-discretionary bonus under the FLSA. So what that means is that that payment that you pay, that incentive pay or that temporary bonus should be included in the employer's overtime calculations. So if you implement that temporary bonus and say you pay employees $2 more an hour during a set time period, you shouldn't be using the normal hourly wage to calculate their overtime. You should be using that increased hourly wage to calculate their overtime, even though it's temporary. And the reason why it's a non-discretionary bonus is because the whole point of the incentive pay or the temporary bonus is to announce it so that your employees can feel appreciated and come to work for you to recruit more employees. And then employees are expecting it. So the FLSA would say, since they're expecting it, you would have to include it in the overtime calculations. And lawsuits are likely for failure to comply with this. Plaintiffs' attorneys are looking for FLSA actions left and right and class actions, which can be very difficult to defend and expensive. So be on the eye, look be on the lookout for any wage and hour law violations relating to the FLSA. Be looking at your overtime calculations. We also said we were going to talk about the ADA and what's trending with the ADA. One of the things that's trending are failure to provide accommodation lawsuits. So in 2020, even during the pandemic, there were more lawsuits for failure to provide accommodations than ever, with over 6,000 cases being filed. So that's completely different than what we were seeing in 2015, just say a few years ago. And I see that we're running out of time, so be aware of that. And don't get to talk much about diversity and inclusion, but be aware of what's going on in the workforce with your employees on a day-to-day basis in their personal lives, and be thinking about how you can incorporate diversity, equity, and inclusion training to impact your bottom line, which it's not a waste of time. It will improve your bottom line and lead to significant business outcomes. So it's something to consider. And Carl and I can be contacted anytime. Here on the screen is our email and our phone number. And we apologize that we don't have time for questions. We had a lot to cover here today with you guys.
Right. Thank you very much, Jade. Some of the topics that we touched on at the very end are significant. And especially in 2021, moving into 2022, it's very expensive to have a problem with the Fair Labor Standards Act. And also the diversity training is extremely important, especially when it comes to the Section 7 rights under the National Labor Relations Act involving social justice movements, etc. Now, we'll be more than glad to talk to you or answer any questions. Thank you so much. Be on the lookout for more presentations.